this live video session as we get started. I hope everyone is doing well. If you can hear me and you can see me very good, please drop USA in the chat box. Drop USA, or you can just drop an emoji of the US flag. And let's make sure that you guys can see me and hear me. I think my microphones are all on. And so hopefully you can all see me and hear me. Drop in USA or type in USA. Alternatively, you can just drop the emoji of the US flag. Today, we're a little early. We usually try to come on live Fridays at 1 p.m., but I have an emergency happening later on. So I decided to come live. This is a really live session. This is a really important live session. And we're live across our social media platforms: Facebook, LinkedIn, TikTok, Instagram, YouTube. Yeah, we're going to be sharing my screen on YouTube, LinkedIn, and Facebook. I'll be showing you guys some, some documents, just a little bit of it. I won't bore you guys too much. Oh, someone cannot hear me. Instagram, I understand you cannot hear me. If you're on Instagram and you cannot hear me, please drop. If you can hear me, drop USA. Let me make sure you guys can hear me. I'm not sure what is going on, but I'm seeing other people drop USA. Audrey Nas, you might want to increase your volume because I can see people say they can hear me on Instagram. Okay, great. Thank you so much. Today, we're going to be discussing what's happening. We have some very interesting numbers, and we're going to be sharing those numbers. We're going to be sharing those numbers on our social media soon about the numbers when we are talking about deportation, deportations, how many people have been deported so far, and what ICE is currently doing to push those numbers, because unfortunately the numbers are really low. I mean, they are lower than the expectations that Trump had. And so these are the latest strategies as of this week that ICE is employing to push the numbers up. And as I keep saying, if you don't want to be a target, the difference between being a target of deportation and not being a target is having the right knowledge and taking the right steps. It starts with having the right knowledge. Okay, so we're going to be discussing today what are the tools that ICE is using in their toolbox to make sure that the numbers go up. That's what we're going to be discussing today. And we're going to get started. I'll tell you guys that, what is going on is not necessarily so much due process, right? You know what due process means, that you are entitled according to your Fifth Amendment, right? So long as you are in the United States, no person shall be deprived life, liberty, or property without due process. If you are in the US, then you're entitled to your due process rights. But what ICE is doing now, people have nicknamed it due process. They want to do it now. They're doing the deportation. Do now. There's no due process. Just do. Deport. Just remove all obstacles, remove all barriers, and just get the people out. And they've been changing some of the policies in anticipation of this moment. One of the things that they did was to roll back the sensitive location policy. If you guys remember, we shared right here previously, ICE was limited in carrying out enforcement and immigration enforcement and certain immigration actions in certain sensitive locations like churches and schools and hospitals. And when Trump came into power, he said, nope, we're rolling back that policy. It's not happening. ICE is now empowered to go into churches. They are empowered to go into school. They can conduct immigration enforcement. They can arrest people. They can interview. They can carry out whatever they need to carry out. They just need a dose of common sense to carry out. And they were not going to restrict ICE in the carrying out of their duty. So and as I say, if somebody is empowered to do something and they are only limited by a healthy dose of common sense, then it's going to vary across board, because we know that obviously common sense varies in terms of the amount that everybody is endowed with. It varies, and so we have to rely on the common sense of people. Well, what if the common sense is very low? Then there's a problem. Somebody may have a reasonable amount of common sense and should know how to handle things. Now, yes, so ICE can go out and carry arrests, interviews, just immigration enforcement in sensitive locations. There are some churches that brought, or some groups that brought an action in court. I believe it was to the district court in Maryland, Justice Frederick Dabney. And, she said she was not going to block ICE from carrying out arrests and immigration enforcement in churches, okay, and in courts, okay. So remember, you guys, the connection is that previously ICE was also limited in enforcing immigration actions in sensitive locations like courts, because the point was that you want there to be a sense of justice. Now, if people have due process rights, they want to have their fair day in court, they want to tell their story, they want to be listened to by a neutral arbiter who's a judge. If they are supposed to go to court and you come there to arrest them, then you are eroding the sense of justice. People will not be willing to go to court. If they have a criminal case, then they're not going to come out to court. So how would you intend to keep the community safe? Because you will not be able to prosecute people for the wrong they've done. You will not be able to get to the bottom of cases. So that was the reasoning behind limiting ICE arrests to places other than these sensitive locations. But now it's like, okay, go there. You can go into courthouses and arrest people, and that's what's happening. Immigration courts across the United States. We've confirmed about 12 cities so far this week where there have been active ICE involvement. We are going to share the list of these cities in this video, and we'll also share it across our social medias. We anticipate, obviously, this is going to be a nationwide trend. And so I'm going to give you the things you need to know, understand what to look out for, and what to do to make sure that you are not a target. You are not a target of what is happening, okay? All right. So there are 3 tools that the government is using to speed up deportations. The first one that they did is that they limited something called administrative closure. They've limited administrative closure. Okay, so during President Biden's time, he encouraged administrative closure, and administrative closure is a type of docket management tool, right? I'll show you guys evidence from this. Maybe I should share my screen now, and then I'll show you guys how many cases are pending in immigration court around the United States. And as I've said previously, on our social media pages right here, the number of cases that are are 2022, I believe it was just about under 2 million cases currently, according to the government. According to the government themselves, they have confirmed, the U.S. government in this EOIR, they've confirmed themselves that there are currently over 4.1 million cases pending in immigration courts. If you look at this document I'm sharing here, it's actually a director's memorandum by Sir Owen, who's, I believe, the director of the EOIR, Executive Office of Immigration Review. That is the federal agency that takes care of or handles immigration court proceedings. Now, these numbers are from the memo that was released in April 2025, just 2 months ago. Okay, it says that, let me just read the sentence here to tell you guys. For instance, between January 2013 and January 2017, the number of administratively closed cases increased from nearly 172,000 to over 268,000. Over that same time period, EOIR's backlog, that's immigration court's backlog, increased from just under 550,000 cases to nearly 859,000 cases. Okay, that was by 2017. We had nearly 860,000 cases in immigration courts pending. Now let's move to the period between January 2021 to January 2025. The number of administratively closed cases increased from nearly 278,000 to almost 400,000, so 392,000, almost 392,000. Over that same period, immigration court's backlog, that's EOIR's backlog, increased from approximately 1.68 million cases, 2021. We jumped from 1.68 million cases to over 4.1 historic million cases. This has never been seen in the history of the United States. And President Trump said it on his own app, Truth Social. I think we shared it on our social media pages. He said former President Biden brought all these people in, millions of them, without due process, and is now asking for due process to get them out. That wasn't possible, and that was going to take several years, 20 years. And so they are not going to be using due process for everybody. They are going to get out as many people as possible. Okay, they are going to get out as many people as possible. Now, let me go back to the discussions we were having. This was just to back the numbers I was giving you up. Okay, so first of all, you have to understand that administrative closure, let me explain, it is just to manage the docket. And what does that mean? It means that immigration court or the judges, let me put this in perspective. There are just about 71 immigration courts throughout the United States. And we have, I believe, about 700 judges. It keeps fluctuating because some of them get fired, and whatnot. 71 immigration courts throughout the United States, over 4.1 million immigration cases pending. Now, administrative closure means that, listen, courts' resources are finite, right? There's a limit. They are just human beings trying to go through these cases. Asylum cases alone can take sometimes about 5 years to adjudicate because it's a lot of information that the judges have to, review. People have to have their day in court. They have to have the master calendar hearing. They have to plead. Then they have to. They can sometimes have a second master calendar hearing. Then they can set them up for individual hearing. Some of these people have witnesses. They will give their own testimonies and they'll have witnesses. There's direct examination, there's cross-examination, there is re-examination. The judges can ask for, there can be continuance when they say, okay, go and brief this issue or go and tell us why we shouldn't do this or do that or whatever. Okay. So it can take sometimes about 5 years or 4 years just to adjudicate one case. Obviously, in between, there'll be other cases that are being adjudicated, but the immigration courts are under so much pressure. So administrative closure is saying that, you know what, if somebody has a good reason in why they want us to temporarily pause their proceedings, and that's what administrative closure is. It is temporarily pausing or putting on hold or temporarily suspending a case which is ongoing in immigration court. And so what administrative closure as a process does is that it will remove a case from the immigration court's active calendar and place it on a pause hold. And sometimes, according to even EOIR, immigration administrative closure can keep a case paused for 15 to 29 years. Okay, and some of the reasons, the most popular reason I would give for administrative closure is that sometimes somebody is sent to immigration court and then the attorney can ask for something called administrative closure. It's a type of prosecutorial discretion. And what we're asking is that, okay, you brought this person to immigration court, but he's gotten married to a US citizen, and his US citizen wife is applying for a marriage-based process for him with USCIS. We've gotten this I-130, the fundamental foundational petition, approved. Can we administratively close this person's case in immigration court and then allow us to pursue the relief with USCIS? You see, this is pretty much commonsensical, because it's just like, in the regular world, you can't have two sailors in a boat. It's going to go, one person will be going north, one person will be going south. Whose adjudication or decision will we listen to? Okay, so the point is that at each point in time, when you are going through the immigration court, the immigration process, your only one body should have jurisdiction. It means that body is in charge of adjudicating the case, because if there are multiple agencies that have jurisdiction, then there is a possibility that you're going to have contradictory adjudications or decisions. USCIS will say, okay, no, leave the United States because your green card is denied. And then immigration courts will say, oh, your green card is approved state. So it's like, okay, which one do I take? So to avoid that kind of confusion, and just to backtrack, USCIS cannot deport you from the United States. So even if they send you a letter telling you leave the United States, there are certain things you can do to make sure everything is fine. That's just by the way. But at each point in time, only one agency has jurisdiction. And so if it's an immigration court and then your lawyer asks the judge, okay, can you administratively close and let's transfer jurisdiction to USCIS, let USCIS go through the case, and once it's approved, we come back to immigration court and tell the court that, can you now terminate the proceedings? I have my green card. I've been able to even go on and become a US citizen. Imagine that it happens so often. I mean, it does happen. So admin closure says usually, you want to pursue relief outside of immigration court in front of USCIS. And sometimes admin closure could also be, there's just currently nothing that well, let me say that for when Biden came, one of the bases that they were promoting admin closure was that if your case was a low priority or law enforcement case, right? So it means that, oh, you don't have any criminal records, like you're not really a priority of enforcement. Then they'll say, okay, let's admin close these people's case because they were, low priority, and let's focus on those whose cases were high priority and adjudicate those cases. Okay, so that's why administrative closure is sought. Now, the memo which was released, the memo I was just sharing with you guys was actually, let me just share that again here. It was actually released in April 2025. The exact date is right here. The memo is called Policy Memorandum 2529. That's the name of the policy memo issued by Sirs Owen, who's the acting director of EOIR. And, he canceled Director's Memorandum 2203, which was what former President Biden had instituted to encourage prosecutorial discretion. Okay, now if you review this memo, one of the very striking things it did was that it's saying that administrative closure is not really a docket management tool trying to reduce the burden of judges in immigration courts. They disagree, and that it has rather led to more pressure in immigration courts. It has led to increased backlog, and so admin closure is just not helping. Additionally, instead of actually resolving cases so that people who are not supposed to be in the United States will be ordered deported or removed from the United States, admin closure is actually being used to save people from deportation, and is being used as a de facto amnesty program. Okay, can you guys see this here? It's being used as a de facto amnesty program, and what that is doing is that the memo was accusing that some undocumented immigrants, when they don't have any possible available relief, they will apply for or they'll seek for administrative closure, and then they will, before they do their admin closure, they will file an application for relief. Like they will maybe do an asylum application if they're eligible, or cancellation of removal, or whichever other type of application. Then they will admin close the case. That means they filed an application for relief, but they paused the case. And once you have a case pending in immigration court, you can continue to renew your work permit. And so these people will then continue to renew their work permit indefinitely, continue to live in the US. And so, the reason for canceling or rolling back or rescinding or restricting admin closure is to prevent people from using admin closure as a tool to just live in the US with permission from the court. Their cases are administratively closed, meaning the judge will not issue a decision in their case and deport them. So they are here, they are working, but they know that they don't have any type of available relief. So it's kind of like an amnesty program, is what that memo is saying. Okay, the April 2025 memo is saying. Okay, no, I marked this. We're not going to go into the major questions doctrine. Okay. Yeah, and there was a part that also mentioned that, these, I think I already mentioned it, sometimes averagely people whose cases are administratively closed, it can be closed for 15 to 29 years. And, from all these, during those times, they can continue to work and live in the US. And so, okay, there you go. It says here on page 5 of the memo. Page 5 has a lot of the juice on this policy memorandum. It says, on the contrary, the average length of time that a case is administratively closed at the immigration court level is approximately 15 years. Okay, 15 years, and approximately 29 years at the board level. Okay, so these averages are not good. They are not temporary. It's like an indefinite measure for them. Okay, now let's move on to the second tool. Let's move on to discuss the second tool. We are running out of time, so don't worry, ask your questions and we'll answer the questions as best as we can. Okay. So the second tool that ICE is now using, well, before we move on to the second tool, let me just conclude again. So the goal of the administration is to restrict administrative closure. What they say, restrict administrative closure, they are saying, okay, don't put people's cases on hold. Let them come back to court. Let them come back to court, have their cases in court, so that when their cases are denied, we can deport them, or have them come back to court so that we can dismiss their case, arrest them, and deport them. And we're moving on to the second strategy, where even if your case has been administratively closed, you should come back to court, so that third strategy, we will dismiss your case, arrest you, and deport you. So let's move on to the second strategy. Second strategy is motion to recalendar. This is the second strategy that ICE is using to be able to push the deportation numbers. And these strategies don't stand alone. They are being used in tandem. They're being used together with other strategies. Okay. The second thing is motion to recalendar. DHS or OPLA. The OPLA is the legal arm of ICE. They are recalendaring about 400,000 previously closed cases under administrative closure. We've shared a video on this as well, I believe. We're going to be sharing, I think we shared posts on it, the video where the team is still editing it, and they'll put it out very shortly, so you'll see what's going on. Now, OPLA, which is, as I said, the office prosecutor, I forget the full name, but OPLA is the legal arm of ICE. OPLA is the legal arm of ICE, and they have been instructed that they need to file all the cases that were administratively closed. They need to file motion to recalendar. Motion to recalendar is to bring back, it places a case back on immigration court active calendar. And in order for you to do this, there are certain things that you have to follow to do a motion to recalendar, okay? But the point is that ICE or DHS, I should say, DHS is saying that, look, all cases that were administratively closed in the past, they are dormant. We are reopening them. We are bringing them back to court so we can take action against them. If you had a long pause in immigration court, you are now being summoned back to court, and you are going to go back to, pursue whatever you had to pursue if you are lucky and your case is not dismissed. Okay, let's go into that. Now, in order for there to be a recalendering where your case is brought back to the court docket, there has to be a motion. There has to be a motion. A party has to move the motion. So it can be you, the respondent, or OPLA, the DHS. DHS can say, okay, we're the ones bringing the case back to court. You have to tell the judge why you are seeking recalendering. It has to be for a good reason. You are telling them that something has changed, and so you want the case back so that it can be adjudicated. Okay. All right. Now, if your case is recalendared, there's a motion to recalendar on your case. You have usually 10 days to respond, 3 days if the motion is mailed to you, and you can oppose the recalendering. If nothing has changed in your case, you can oppose the government and say, no, I don't believe that it's in the government's best interest to actually recalendar my case, and then you give whatever reasons for that. And even if, as I've said in the past, the judge goes on to recalendar your case and you oppose it, you can try to fight against that. Okay, you obviously have to speak with your attorney to make sure that recalendering is not good for you. If you have available relief to pursue in immigration court and your attorney reviews and sees that, no, this is good, let's go on, then you should go on. If not, if you have something with USCIS, maybe you have alternative forms of relief that would be interrupted by immigration court, then you want to bring that to the attention of the court and see, just let the court know if you oppose. Pretty much, you have to respond to the recalendering. Otherwise, your case will be recalendared and you will be brought back to immigration court. Okay. Now, the third strategy they are using on the back of the recalendering cases is the motion to dismiss. Motion to dismiss. So the government, DHS, they are filing these unilateral motions to dismiss once you are back in court, or for those who have cases in court. And this is specifically being seen during master calendar hearings for people who have been in the US for less than 2 years. They have some type of inadmissibility. They didn't come in with proper documents, or they have some type of fraud, came in with some type of fraud. This is because obviously when your case is still in immigration court, then ICE cannot just arrest you and deport you. Usually you have to have your day in court. Your case has to be adjudicated to its logical conclusion. And then if your case gets denied, ICE can execute the final removal order against you. But even when your case gets denied, you have the option to appeal. And once you file an appeal, then you can likely do a stay of that deportation or block that should not attempt to deport you because you still that means the immigration judge's decision is not final. You're still continuing to go through the immigration court process. Okay. Now, sometimes so ICE can, or yeah, let me say DHS or ICE, they can, let me say DHS in immigration court, they can actually say that, you know what, we're dismissing a case for good reason. You, the respondent, you can also apply to get your case dismissed from immigration court. And there are 7 grounds under which you can do this. Number one, if you are a national of the United States, then you shouldn't be in immigration court. Okay, so a national of the US is, they're not citizens, but they owe their allegiance to the United States. US nationals, these are the people who, American Samoans and Northern Mariana Islanders, who choose to become US nationals instead of US citizens. I believe US nationals do not vote. That's one of the differences. And because they are US nationals, they are pretty much US citizens also, and US citizens cannot be placed in removal proceedings. So if a person is a US national, they can get their case dismissed because they are a US national, they're able to prove it. Okay. Then secondly, you want to note that under immigration law, US citizens, they are not subject to removal or deportation at all, which is even probably why the US citizens are not specifically listed under why a case can be dismissed from immigration court, because you shouldn't even in the first place bring a US citizen to court for deportation. Denaturalization proceedings are different if you want to strip them of their status as US citizens. Now, the second reason why a motion to dismiss can be brought in court is that the respondent or the foreign national is not deportable or inadmissible under US immigration law. They are not, there's no grounds for you to deport them. They are not inadmissible. Number 3, where the respondent or foreign national is dead. The person you are bringing to court just died last week. So are you going to cross-examine a ghost? You just need to dismiss that case from court. So you let the dead bury the dead. You let the person rest in peace. The person. So you see, sometimes people will have immigration court proceedings, and then in the middle of it, they die. The proper thing to do is to seek a motion to dismiss, so that you let the person rest in peace. You don't, so that's a proper and practical thing to do where the person dies. Then when the person is not in the United States, the person has left, like, you know what, just F it, and then they just leave. Some people are like, no, I can't take it anymore. It's been 3-4 years, all my money is gone. It's not worth it. And they just leave. If the person leaves, the next course of action is just dismiss the case so that the government can pursue other cases who are here to pursue their cases, other people. Okay. Imagine if we have 10,000, 20,000 people who are dead on court docket, they are calling out their cases, and we're just wasting time sitting in court. Or the people have left and you are wasting time processing their cases. No, we have to preserve resources, or use the resources for the people that want to pursue their cases and who are here. Okay. Then notice to appear wasn't properly issued. And number 7, this is the grounds that the government is using to get people's cases dismissed. Circumstances of the case have changed after the notice to appear was issued, to such an extent that continuation is no longer in the best interest of the government. Now, if you go to court and the government is saying they want to dismiss your case, one of the reasons you can use to oppose that dismissal is that nothing has changed. If you were trying to pursue a particular relief in court, you have a right to pursue that relief. If nothing has changed, and the government cannot bring a dismissal request because they are claiming that something has changed. The only thing that has changed is that they want to be able to dismiss your case. Once your case is dismissed, some of the judges are telling the people you are free to go. You step out of court, then you are arrested by ICE and you are deported through expedited removal. And expedited removal, you've been here for less than 2 years, you didn't enter the US lawfully, you are amenable to expedited removal. some of the things you have to understand is that not everybody is amenable to expedited removal. Expedited removal, if you can prove that you entered the US lawfully, you are not amenable to expedited removal. If you can prove that you've been in the US for more than 2 years, continuous presence of more than 2 years, you are not amenable to expedited removal. So what you want to do is, if you are going to court, you must be ready to oppose. If you are going by yourself, I mean, I don't recommend that you go to court alone. I recommend that you go with your attorney, family members. Your attorney is the most important because they're the ones that can advocate for you. The family members, some of them get very emotional, they'll start crying and all that. But you need somebody who's detached from um your situation and can properly advocate for you. Okay, you can oppose when the government is saying they want to dismiss. You can oppose and say you want to have your day in court. Matter of Herrera. I was reading this case law this week. Very interesting case law. Let me see if I can share the same. This person was very interesting thing happened with this case. Matter of H. Ferreira. I believe it was 2024 December, decided by the BI. 2023 December 2023, I believe it was decided by the BIA. And in this case, the respondent, he got married to a US citizen and he got a conditional permanent green card. Okay, you guys know what a conditional permanent green card is. You get a 2-year green card and you have to remove the I'm sorry, you have to file to remove the conditions on the green card 90 days before the 2-year green card expires. So this person got a 2-year green card, and unfortunately, he got divorced from the spouse. Okay, he got divorced from his wife, who's the US citizen, 2010, and then he filed the application to remove conditions. After you get divorced, you get a 2-year green card, you get divorced, you can still file to remove the conditions on your green card and apply for a 10-year green card. When he did that, USCIS said that, oh, we reviewed your case and we feel like it was just an immigration fraud case. You got married to evade US immigration laws. Pretty much that's what they said. It was just that he got married for the sole purpose of evading US immigration laws. 2011, USCIS, they terminated or they ended his status as a green card, conditional green card holder. And then they started immigration proceedings against him and they charged him as removable from the United States. Now, in the immigration court, the man, Herrera, what he did was he said he wanted the court to review his case. Okay, he wanted the court to review his case. The immigration judge said that DHS did not establish that the Herrera was removable, and the immigration court just terminated the removal proceedings because the government has the burden to prove in court that you are supposed to be removed or you should be deported from the United States. If the government doesn't do that, meet its burden, the case will be terminated and you'll be free to go. You see, now the Herrera man filed another 751. He filed another form 751 to remove the conditions. He filed it again with USCIS. And again, what we spoke about comes to bear. Now his case has been removed from immigration court, so USCIS has jurisdiction. And he said that he entered the marriage in good faith. He was not at fault for failing to file a joint petition and, all of that. USCIS again denied this man's removal of conditions. And then they put him again in removal proceedings. And under the NTA, the notice to appear, that's what will have your allegations from immigration court. It said that Herrera failed to establish his qualifying marriage, that he entered into it in good faith, and that he didn't qualify for an extreme hardship waiver. So 2019, think about it, since 2010 divorce, he had been going back and forth. 2019, at the hearing, guys, guess what DHS said to the judge? And it's actually been happening to people. DHS said that it didn't have Herrera's file, and that it wanted a continuance to locate it. That's just a diplomatic way of saying we lost the guy's case. And USCIS does that a lot. They can sometimes lose your case. We've had clients whose cases have been lost by USCIS. USCIS said they couldn't locate, so they've lost his filing, and that the judge should push the hearing to another date so that hopefully they'll find the file by the time and then continue with the case. Respondent didn't object, and he said, okay, he just wants the case to move quickly forward so that he can move on. The judge postponed the case for an additional month, so the next month they were back in court. At the hearing, DHS said they still can't find this guy's case. It's lost. And guess what the DHS did? The DHS attorney did. DHS attorney, well, the judge asked him, do you want to move to terminate for failure to prosecute the case? And DHS said, yes, just close the case, end the case. Then the respondent said that, no, don't cancel, don't dismiss or terminate my case. Don't terminate my removal proceedings because you're going to leave me without an avenue, because USCIS has denied my form I-751. And I'm seeking a review in immigration court. If you terminate it, then what do I do? Then the judge made an erroneous decision. The judge ruled in error and said that, oh, well, DHS has said they want to terminate, so I don't want to interfere with DHS's discretion. And the judge, despite Herrera's objections that don't terminate my case, the judge went ahead and terminated. So Herrera brought this case to the Board of Immigration Appeal, appealing and said, no, the judge was wrong. Now, here's what you have to, let's look at this. I mean, it's more conditional green card, but let's take a look at it. It says, according to law, right, after terminating the conditional permanent resident status, DHS, so when DHS terminates your resident status, if you're a conditional resident, they have to notice, they shall issue a notice to appear. Congress has provided that a decision by USCIS to terminate a non-citizen's conditional permanent resident status is reviewable in removable proceedings. So that's where the person has relief and can review it. The judge can review and say, did USCIS terminate well or not? It's the judge that can do it. Because the person, Herrera, or the conditional resident cannot appeal from the decision. They cannot appeal the decision that has been made, that has denied them their conditional resident status. So no appeal shall lie from the decision of the director to deny a waiver of the joint filing requirement. If your waiver application is your removal of conditions based on waiver, if it's denied, there's no appeal. Where the basis for USCIS denial of the Form 751 is the denial of the waiver of the joint filing requirements, immigration judge will review the denial of the waiver as well. Okay, so the point was that the guy's Herrera's only relief was before an immigration judge, because the law says that once your case is denied, under these circumstances, there's no appeal. Go to court. He's been sent to court. You'll be sent to court. He's been sent to court. Now you are dismissing. Where do you want him to go? So they argued that, look, the fact that you've lost my case or you've lost my documents is not an enumerated ground under which you can terminate proceedings. You guys remember I just discussed the 7 grounds. We discussed about 6 of them, but it doesn't say in the law, in the regulations that, if DHS loses my file, then you can, if DHS loses a person's file, DHS can then terminate or end their proceedings. And that DHS does not have sole authority or unilateral authority to cancel a notice to appear once removal proceedings have commenced. This is case law that is backing the fact that if you go to immigration court and DHS is saying they want to terminate your proceedings, you can oppose and you can object to this, because the judge has to review everything happening. The judge you can oppose, and the judge has to look at your reasons and then determine whether um, this is right. Okay. Now, yes, if you look on in the case, it said that there was a legal limbo that the guy was left in because he was no longer a lawful permanent resident. Yet he had also not been found deportable. So he's in the middle. You won't give me a green card. You said I cannot be deported. I've come to court to you've terminated proceedings. Where do you want me to go? USCIS can also not, I cannot appeal. I cannot. What do you want me to do? So the guy was left in a legal limbo. And the BIA said that that legal limbo is not simply being out of lawful immigration status, but the inability to access the sole form of review expressly provided by law, expressly provided for by law. Given the significance of a respondent's interest in securing review of a denial of a petition to remove the conditions, the judge should have reviewed the denial of the form I-751 upon the guy's request. Okay, so in this case, the appeal was sustained. The immigration judge's decision was vacated and removal proceedings were reinstated. The guy was supposed to go back and then have his day in court. Okay, so this case is really solid for being able to make arguments in courts that do not dismiss my case. If I have relief that I can only seek in immigration court, you are dismissing my case. Where do you want me to go? Right? Because if you agree to a dismissal, then what they are doing is that you are free to go. You leave the courthouse. The ICE officers are waiting in the hallways, in the elevators, outside, and they will arrest you, put you in expedited removal. And these people being placed in expedited removal are deported within a matter of hours, a matter of days. You are gone. So if you happen to be going to court by yourself, which I highly don't recommend, make sure you have evidence that you are not amenable to expedited removal. You want to show that you've been here for more than 2 years. One of the strategies we're using at our law firm is to be able to file written pleadings. And then we can even move for, so once we filed the written pleadings, we've prepared everything, and then we can request that they should schedule our client for an individual hearing. Okay, because now the court has everything they need. Because sometimes you can go to court and do your master calendar hearing. You can also do it obviously via WebEx or online. Some of the judges are no longer agreeing to this WebEx because the truth of the matter is that the WebEx is also quite problematic. It allows for flexibility for attorneys' schedule, but sometimes during WebEx, which is the virtual system for court hearing, the judge can sometimes not hear well. You, the respondent, sometimes you can't hear well. Witnesses are on WebEx and they drop off, connection issues. The judge is not able to assess credibility, look at things. It's just the in-court experience is usually better. So some of the judges just say that, we are not allowing you to do WebEx, come to court. And if you are coming to court, then you kind of want to make sure that you've covered your back before you get to court. Okay, you want to make sure you've covered your back before you get to court. You want to again file everything you can, what we're doing, filing things we can prior to court, and then being ready to object to a dismissal. Consider, also doing the stay of removal packets for our clients, the form I-246, in situations where we have, the person could have, let's say, a relief pending, right? It's like they filed an I-130, it's pending, and they're married to a US citizen, they're looking to adjust in course, things like that. Looks like at the end of the day, they could probably become US, green card holders. So what's the point of dismissing and then placing them in expedited removal proceedings? Okay. Again, filing written pleadings and then filing the relief and doing a motion to request an individual hearing is also one of the strategies so that we can skip the master calendar hearing, which is where some of these arrests are happening. If the immigration judge grants DHS's motion to dismiss, we can consider filing an appeal to the BIA. And while the appeal is pending, ICE cannot also pursue expedited removal because, again, immigration judge's decision is not final. Now, when you are arrested anyway, even in court, you can always assert your fear to being returned to your home country if you are afraid to return to your home country, and you will be given a credible fear interview. Keep repeating it that if you are afraid to return to your home country, tell ICE that you are afraid of this. Very recommended to keep evidence that you've been here for more than 2 years to take you out of expedited removal, because that's the part where you don't have due process. It's within a day, 3 hours, 5 hours, you are back in your country. So you want to make sure that you do what you can to not be part of expedited removal. One of the other tools I mentioned, I wanted to talk about was that apart from rolling back the sensitive location policy, they also expanded expedited removal to apply nationwide. Previously, it was 100 miles near a land border. If you had been here in the US for less than 2 weeks, you were found inadmissible. And now it's if you've been here for less than 2 years, expanded in time and expanded in terms of geography throughout the United States. So everybody's game for expedited removal so long as you didn't enter lawfully, you've been here for less than 2 years. So you want to make sure you have evidence that you are not part of what Section 235B says, the people that are amenable to expedited removal, you'll find it there. And you want to show them that you're not part of those people. You are afraid to return. You got to say it. Express your fear. Now, let's look at the cities where we've confirmed these arrests happening. So, again, the strategy is that you go to court. So the strategy is not, number one, they're restricting administrative closure. So everybody must come to court. Number two, they're recalendaring cases that were administratively closed, putting them back on the case dockets, giving them dates so that they'll come to court. Number three, once you are back in court, they'll dismiss your case if you are amenable to expedited removal. Once you leave the courtroom, they will arrest you and then place you in expedited removal. So we've seen, San Diego. Let me see. I put the other list here. Charlotte, North Carolina. San Francisco is another city where we confirmed as well. So the San Diego, California, Dallas, Texas, Phoenix, Arizona, Los Angeles, California, Chicago, Illinois, Seattle, Washington, Buffalo, New York, San Francisco, California, Miami, Florida, Santa Ana, California, New York City, New York, Charlotte, North Carolina. I believe it's 12 of them. Yeah. But again, this is a nationwide policy, so we expect that more of this is going to happen. 4.1 pending cases obviously means that they need to push these things as much as possible. Okay, so during your hearing, if the government is seeking to terminate proceedings, you object, tell the judge that you oppose it. Even if the judge terminates, you can appeal this as well. Okay, guys, let me see if there's some questions that we have. Today we didn't do too many questions because we had a lot to discuss. But let me see if you have some questions. Please drop them here. Okay, let me just take this off because I'm done with. Okay. Charlie Zoo says, hello, lawyer. Charlie's on YouTube. Do all I-751s require an interview? No, not all I-751s require an interview at all, but now they are stopping the interview waivers. So they are requiring people to come in for interviews. I'm going to release, I think we recorded a video on that as well and shared across our social medias. They're stopping interview waivers. We confirmed with offices, USCIS field offices, other attorneys, and attorneys across have confirmed that several field offices are saying that there's no longer going to be a waiver, interview waiver. They want people to come in. So yes, now all 751s are likely to be called for an interview. So just prepare yourself and your mind. And guys, one of the things that I've noticed, and I tell some of my clients, is that the trick about the conditional green card. If you apply for a conditional green card, right? Conditional green card is that. So there are two types of green cards. We have the 2-year green card and then the 10-year green card. You get the conditional green card if you've been married for less than 2 years on the date your case is approved. And you get a 10-year green card if you've been married for more than 2 years when your green card is approved. What immigration does is that when you apply for the conditional green card, they are usually quick to give it to you. They don't do too much digging. So people will file, get the 2-year green card, and then they lose guard and think that, let's get it. I'm a green card holder. But one thing they forget is that time runs, and it runs super fast, very, very fast. So by the time you are busy sipping margaritas, lying on the beach, you haven't put your evidence together, 90 days before the 2-year green card expires, you have to file again to remove the conditions. And that is where the trouble is. The 10-year green card application process, you'll be given a 4-year receipt, meaning the case can last for as long as 4 years, 5 years, sometimes even more. For some of our cases, it's been really fast if you're able to prove really strongly, but it's not very common. Generally, the removal of conditions, if you're trying to move from the 2-year green card to the 10-year green card, they do a lot of investigations, they review your case, and that's where they cause a lot of trouble. And so once you get the 2-year green card, you should not lose guard. You have to continue to diligently put together the bona fides of your marriage, continue to build your equities to show that you have a real marriage, your marriage is evolving, things are going on. If you fail to do that during the removal of conditions process, you'll have problems, okay? So don't lose guard just because you get a 2-year green card. It's just kind of like they just show you that 2-year green card for you to get excited, and then they can jump in on you when you are not aware. So you got to stay vigilant, make sure you continue to put the bona fides. If you sometimes, instead of saying I love you, you can text it to your spouse, keep these evidence, time stamped, everything, date stamped, and all that, and that will help you when you're about to remove your conditions. Prince Fiajibe says, joining live from the motherland. We see what you do and we're proud of you. Thanks for everything, sis. Oh, thank you so much, Prince. We see your comments and everything. We really are grateful. Super grateful. I got Andrew Lopez on YouTube says, I got green card from VAWA, but my ex-wife was green card holder. When can I apply for citizen, 5-year or 3-year? When you get your green card through VAWA, you can typically apply for US citizenship in 3 years, and that. So yes, but I would highly recommend, please make sure you speak with an attorney, speak with us, and then we can review more and then assist you guys. People are applying for US citizenship and they are being, their cases are being denied and they're being put in removal proceedings. People who have any type of criminal issues in the past, if there's any type of fraud issue you had in the past, anything that was not straight, you want to make sure you speak with an attorney before you apply for citizenship, because the February 28th policy memo NTA issuance said that if you apply for citizenship or naturalization, and if they find there's anything that makes you deportable, they should deny your case and send you straight to immigration court. So you're trying to get to US citizenship, but then you could end up in immigration court if you don't take the right steps. All right. Ken Jallo says on YouTube, hello, is it safe to travel right now within the US as undocumented immigrants? I think we created a video on this, whether it's safe to travel in the United States as an undocumented immigrant, whether it's safe to fly We did a live video on this last week, so I showed you what Christine Noem said, that illegal aliens, according to her, should not be flying except they're self-deporting. So, check out those videos and lives and you'll get what you need to know from there. All right, guys. Thank you so much for joining. Let me see. Is there anything on YouTube? On LinkedIn. I didn't see any comments on LinkedIn. If any LinkedIners are watching, please drop a comment. If you're on LinkedIn, Facebook, guys, if you've enjoyed this session, drop me a comment here. USA, type USA, USA. Let me see if there's a final question on TikTok. While you type in USA, let's make sure LinkedIn people can hear me and everybody else has also enjoyed the session. Kin on TikTok says, I got served a divorce order by my spouse. I'm on a conditional green card. What are my options? So you can file a waiver of the joint petition. Okay, so as I said, if you have a 2-year green card, it means that you were married for less than 2 years when your green card was approved, other than more than 2 years. If you're married for more than 2 years, you get a 10-year green card. You're divorced, you have some options. The first one is that you can, so the general rule is that in order for you to remove the conditions on your green card, you have to apply with your spouse jointly to remove the conditions, right? It's 90 days before it expires. But if your spouse has divorced you, you can show that your marriage ended through divorce, and so you are filing a waiver. You're not a joint petition, and the marriage should have been in good faith. If your husband or your wife is dead, you can still file the application to remove conditions from your green card based on the waiver. If you went through extreme cruelty or abuse at the hands of your spouse, you can also file the waiver. If you face extreme hardship, you can file the waiver. So these are the 4 general options that you can use to file a waiver. But the waiver is a little technical, so please make sure that you seek help. The case I just read to you, matter of Herrera, BIA 2023, decided if your removal of conditions application is denied based on a waiver, you go straight to immigration court. There's no appeal process. And that's how a lot of people find themselves in immigration court. So this is not something you want to play with. Make sure you get legal counsel and you can, proceed accordingly. You can contact us. Anybody needs our help. We work all 50 states throughout the United States and around the world, and we're very happy to help you if you need our assistance with any U.S. immigration matter. Make sure you are following all our social media pages, AK Poku. You search us, you'll be able to find us. And you can contact us at 802-780-0564. Okay, you can also Google AK Poku and you'll find us. I'm trying to put the banner for the phone number on Facebook, but looks like it's okay. All right, guys. So if there are no more questions, then we'll call it a day, and I'll see you guys next week, God willing, 1 p.m. EST. Hopefully, we'll be here to share more live updates. Make sure you are following all our social media pages. You're engaging with us, liking, commenting, sharing our posts to encourage us to do more. Thank you all so much for joining in, and I'll see you soon. Bye, everyone. Take care.